We've been enjoying our new studio now at the American Mission Center for some time, but we are really going to put it to great use today. I'm Wayne Shepherd with Dave Zanotti, and let me tell you who's in the studio. And then Dave will introduce a couple of special guests who join us as well today. Alan C. Duncan is our producer, of course. Rob Walgate is here, Melanie Elsey. And I already mentioned I'm Wayne, and Dave is here. And Dave, I'll let you introduce our two very special guests today.
Thanks, Wayne. We're delighted to be able to bring a new level of expertise to our listening audience today on the subject of constitutional law and the dynamic that's going on in our country right now. It's on the state level regarding the question of abortion, abortion rights, protection of innocent life, the question of life in general, and particularly the responsibility that we the people have when it comes to constitutional amendments and statutory representation in the legislature. We have a role to play in this. And so it's going to be a question that will apply not just in the closing days of the major ballot fight that everyone that's been listening to the Public Square knows about all over the country. We've been receiving listener response, Wayne, coast to coast. People realize that this is the beginning of a very long battle, and this is a critical opening scenario here. So we're going to be at the hearing today from Professor Lee Strang, who is a professor of law at the University of Toledo, and from Larry Obhoff. It's going to be hard for me not to call him senator, because even though he's not in the Senate right now, he was not only a senator in the state of Ohio legislature in the state Senate, but also the president of the Ohio Senate. So we have two people with us today who are eminently qualified to start this conversation. So let's get started. Let's start with Professor Strang. Professor, you're an author, you're a professor, you're a law teacher, and you also have a great passion for constitutional law. What about this particular issue as a constitutional amendment? When you look at this, what do you see?
That's a great question. I see an amendment whose text was carefully crafted so that on the one hand, it gives the appearance and gives the rhetorical capacity of its proponents to be able to say that this amendment restores the status quo before this U.S. Supreme Court overruled the Dobbs case to, quote, reestablish the law that existed prior to the overruling by Dobbs. In other words, reestablish the Roe and Casey framework, while substantively and in many, I think, very clever, and I mean that both in a positive and a negative way, very clever uses of text to create an incredibly expansive, maybe the most expansive I've seen, with the one exception of public funding, most expansive right to abortion that would exist. So it's there's this juxtaposition between the rhetorical stance and then the actual law in the proposed issue and to what it is likely to do.
Professor, I've likened this to a playground game of teeter-totter. When I read this language over and over and over again, it looks like it's taking me one direction, but the farther I go into it, all of a sudden I'm leaning in a completely different direction.
Yeah. So just to give one example, one that, if you're an average American who's concerned with your paying your mortgage, having your job, the section 3 says abortion may be prohibited after fetal viability. And that sounds like a limit. It sounds like actually a robust limit, and it sounds like a limit that existed prior to under the Roe Casey regime. But it's actually, when you read the subsequent language in Section 3 and also Section 4 of the amendment, you see that the limitation, if it exists, is very thin and very modest, and certainly not the limits that existed after Casey. So it's an example of what you just said, Dave, which is it seems to say one thing, but in fact it delivers something significantly different.
Wayne, I've got to be honest with our listeners right now. I feel like we're in closing arguments before the United States Supreme Court. And because I've been there, I'm actually having some of the same fluttering in my nerves that I felt when we were standing before the U.S. Supreme Court, because I realize that there are just a few hours left before this election concludes in Ohio. And the sense of importance of every word that's being used right now has actually got me nervous in the studio while we're doing this. So I want to be honest with folks that are listening. The importance of this has really impacted us.
Well, it is very important. And as we've said many times, it's important not just for Ohio, it's important for anyone, anywhere, because this kind of language is going to permeate the effort nationwide eventually, right?
I think so. Professor Strang, do you agree with that?
Yeah, so Ohio, as your listeners probably know, is not the first state, although I think In some ways, this is a major test case for the pro-abortion movement. So there have been red states that have adopted similar language. There have been kind of purplish states that have adopted similar language. But Ohio is really the first state that is one that's significantly trending red, in other words, relatively more conservative. It has significant pro-life legislation, and it's got a well-organized, conservative, right to life, et cetera, establishment. And if the pro-abortion movement can win here, that's very telling and very negative.
Let's talk a little bit more about the language and sort of the teeter-totter that we're looking at here. Abortion law in America has traditionally been statutory. It's been something that legislatures have worked out through hearings and consensus and have been at it time and time again. Of course, when the Supreme Court came in with Roe versus Wade, they kind of changed the dynamics so dramatically that there was very little that legislatures could do to affect the broadest part of the question. And so there were different pieces and parts that came up over the years.
Yeah.
Statutory or constitutional, which seems to be the more logical approach here?
That's a good question, Dave. And I think I would distinguish between the federal Constitution, where the American national Constitution is one that is relatively short, it's relatively pithy, and I think that we might approach that differently than state constitutions. State constitutions, I think, can and should and do have more material in them, so that does kind of push them a little bit towards the statutory context, and there's a variety of reasons we could discuss about that. But your question regarding this particular issue, right? I think if you're in a jurisdiction like Ohio, where you have, and I recently wrote an op-ed about this, and so I'm kind of familiar with the numbers, you have most Ohioans, for what it's worth, a lot believe that there should be abortion for some period of time early in a woman's pregnancy. The vast majority of Ohioans are against partial birth abortion, late-term abortions, abortions typically after 3 months, and even earlier than that. And so when you're in a jurisdiction like Ohio that is trending in a particular direction but has a wide variety of viewpoints by the citizens, that a constitutional amendment is really hard to fit within that kind of nuanced position where the people in that political community are at. Whereas with a statute, this goes back to your point, Dave, with a statute, the legislators can identify particular issues where there's a consensus, like Ohioans are not in favor of partial birth abortion, so we pass a statute eliminating that. So statutes are actually really effective in a jurisdiction like ours, where you have people with a wide variety of viewpoints on some aspects, but have a lot of consensus in other aspects.
Well, let's talk about this as a one-sided amendment. And I don't mean a one-sided amendment politically. I mean, the amendment begins by, in essence, creating a new right that I've never seen before in American jurisprudence, the right to reproductive decisions in the plural, and then enumerates 5 of those subsets of rights, if you will. And to me, they would all be new rights in the Ohio Constitution. But in that establishment, well, first off, let's talk about that. Does that to me, in our years of experience, that's an unusual proposal for a constitutional amendment.
Yeah, I thought when I first read the text, I was surprised by the language that one has both a right to make, and that's typically what's been in the case law from Roe and Casey and other Supreme Court cases, but also to carry out one's own reproductive decisions. That's a more capacious right. It's not entirely clear what that means. Like, what does that gather? I think this is my hypothesis, for what it's worth, that, again, the people who crafted the text of the amendment were very astute and wanted something broader than just the ability to carry out, let's say, a right to abortion, but wanted to put additional restrictions on Ohio school districts, counselors, in other words, a much larger body of people, and their ability to, quote, indirectly interfere with this new thing, this right to make a reproductive decision. So you can imagine scenarios where if there's a school teacher, a student who is considering an abortion comes to the school teacher, and the school teacher gives that young woman advice, and the advice is suggesting to not procure an abortion. It seems like that would not interfere with a right to carry out an abortion, but that plausibly is an indirect burden that interferes with having one's own reproductive decisions. And so I think what it does is it opens up an entirely new and much broader category than existed previously in the law.
Because we haven't had a technical right to abortion enumerated in the state constitution. It's been presumed to be there, and then the legislature has been regulating how that would be implemented or lived out. This is different. This changes the game, doesn't it?
So what I would say, Dave, is that the Ohio Constitution, properly read, especially looking at Article 1, never had a right to abortion, and was best read as to prohibit a right to abortion. And that whatever right to abortion was from the federal Constitution, the Supreme Court's misinterpretation of it. So I actually think that the Ohio statutes that restricted abortion were actually the best interpretation of abortion, and that this is something that's 180 degrees different than the natural rights language that it begins the Ohio Constitution.
Let me break in right now. We are going to come back in a moment. We're privileged today to have law professor Dr. Lee Strang with us today. And our panel is listening carefully and will be reacting later in the broadcast today. So stay tuned for that. We've got much more to learn from Professor Strang here, though, and we'll get back to it in a moment on the Public Square. And if you joined us late and want to catch the first few minutes already and want to go backwards, go to the website, thepublicsquare.com, and listen from the beginning, or use our smartphone app, The Public Square. Stay with us now.
Beth and Kyle Long lost a child to a rare fetal disorder. That is a tragedy. Ohio law protected her right to end that pregnancy. The Longs claimed they had to go out of state because her insurance did not cover therapeutic abortion. She is now a spokesperson for Issue 1. But Issue 1 does not address insurance at all. It never mentions the word. Is anyone ever going to fact-check this story? Please, before you vote, read Issue 1 for yourself at seethelanguage.com. Paid for by Ohio Roundtable.
Spreading the light of liberty across the land. Now back to the Public Square.
Right back into the topic today on the Public Square as we talk about the Ohio Constitution and what voters are faced with. Our guest is Professor Lee Strang. Dave?
Professor, we've been talking about Ohio Issue 1 and the text of the constitutional amendment and the discussion about it being one-sided. Let me suggest there's another place where it's one-sided in that it talks about the right from the perspective of the individual experiencing the questions of abortion, contraceptive, fertility treatment, et cetera. But it does leave someone else out. And it appears in this amendment that there is no consideration for any life rights in regards to the unborn child. Now, I recognize that that's a question of depth in regards to the interpretation of what someone believes or doesn't believe in regards to fetal development. But it appears here that there is nothing of that conversation in this language.
Yeah, that's very astute to pick up on. So when you step back and look at the regime that was crafted by the U.S. Supreme Court in Roe and Casey, there were three reasons that a state like Ohio could use to regulate abortion. One was health of the mother, and that's actually identified as an interest in proposed Issue 1, although it's very restricted, as we talked about a little bit earlier. Second issue was the capacity of the medical profession. So one concern is to make sure the medical profession lives up to its Hippocratic oath to facilitate health as opposed to take away health and life from people. And the third interest was it was given different labels. In Roe, it was called the interest in the potential life, and what we would call the unborn human, the unborn baby. And those two interests are markedly absent in Issue 1, including the very important interest in unborn human beings. And so I think this is another example where the folks who drafted Issue 1 very cleverly highlighted one interest that is a true interest in protecting women's health, but kind of silently put to the side these other two interests, including the most important one, which is the basis upon which states primarily are regulating abortion. And that's the basis about which Ohioans have differences of opinion, although most Ohioans want to regulate abortion, especially as children come to term, because most Ohioans recognize that is an unborn human being as that being becomes more developed. And that interest is markedly absent. And one would have to, I think, only conclude intentionally absent.
How long have Americans been arguing or debating the question about the protection of innocent life in the womb?
Yeah, that's a great question. And both in Roe, where Justice Blackmun had a famous, or I would say infamous and really shoddy history of abortion regulation in the U.S., and then in the Dobbs case, where Justice Alito's majority opinion had, I thought, a really masterful summary of the history of abortion regulation in the U.S. based on the most current research. Americans have debated it, and my picture of that debate, really, Dave, is as Americans following off of England, as we came to understand better the growth of unborn human beings, the development of all of us in our mother's wombs, we came to see the humanity wasn't just, this is Thomas Aquinas, one of my favorite folks, wasn't just at the point of, quote, ensoulment or quickening, but actually, it was actually the point of conception. And by the late 19th century, right around 1870, including states like Ohio, move towards legislation protecting unborn human life all 9 months of the pregnancy, because we came to recognize that. And then really, there was a consensus in the United States from the late 19th century up until the 1950s about abortion is something that should be, if allowed at all, should be rare because of the value of human life. And then, as in many areas of American life in the 1960s, that issue came open again. And then since Roe, it's been really, honestly, a toxic debate in our political environment.
In your studies, has there ever been a time where there hasn't been a concern about protecting the life and health of the mother?
No.
If you were teaching this particular amendment in a law course, where would you start? What would you want people to see?
Yeah, that's a really great question. It's one that's actually going to become real because I'm teaching Ohio constitutional law again this summer, which I love because it's not taught very often. And so one of the sections will be about individual rights. And just like if I taught federal constitutional law, I'm going to teach, which I'm going to teach in the spring, I'm going to teach, the pre-Roe law, Roe, Casey, and now Dobbs. I'll have a story about Ohio's treatment of abortion. And my story will be that by 1870, Ohio came to significantly regulate abortion because it saw that unborn human beings are human beings deserving of full protection, and that Roe pushed Ohio away from that vision, although Ohio continued, like many other states, to try and protect unborn human life to the extent that was legally possible. And that issue 1, if it were to pass, would be truly unprecedented, and not just like in a modest way, but in a dramatic way. So it's unprecedented in the most capacious conception of the term, where what had been Ohio's traditional approach to abortion, which is to largely restrict it, had been flipped 180 degrees on the opposite, and don't even acknowledge the fact that there's an unborn human being at issue. So even Roe, right, which with its companion case of Doe versus Bolton, basically made the United States one of the 2 most abortion liberal regimes in the world. Even those cases acknowledged, even if it wasn't entirely effective, acknowledged the value of unborn human life. And so this issue goes not just in the ways that we've talked about, but goes in its conception of who's at issue in the issue of abortion, basically erases the unborn human being. That's unique. I haven't seen that.
Do you think judges will have a difficult time if issue 1 passes, with people coming to them with serious questions about what do these words mean?
I think some areas are very clear. So, for example, when it comes to issues of parental consent, I think it's very clear issue 1 would prohibit parental consent requirements. I think it's also clear that issue 1 would prohibit state Ohio from limiting late-term abortions. So I think issues that were relatively clear under the Roe and Casey regime and were in a pro-life position are pretty clearly not. And I think the areas of unclarity are actually going to be what we talked about earlier, where there's section 1. It's clear that the right to abortion is much broader than previously because it's a right to make and carry out reproductive decisions, right? That's broader than previously. And the list in section 2 of what a state like Ohio can't do is very broad. It can't indirectly burden, interfere with, or discriminate. I think that may mean, it's not entirely clear, but I think it may mean Ohio, for example, can't fund family health services without also funding abortion. I think that's what that's in there for. So if I'm a judge, I'm struggling with that. And then when you look at number 4, who counts as the government? It's not just Ohio and the governor, et cetera, et cetera. It's actually, I think, every school teacher. And so the hypothetical that I gave you earlier about a school teacher talking to a young woman who's pregnant, I don't think that's actually hypothetical. I think that would in fact happen, and that a judge would have to face the question of whether that conversation that I hypothesized is an indirect burden on that young person's reproductive decision. And so I think there actually are some easy questions, and those are very bad, but there's some hard questions that could potentially also be very bad.
Now, I know that you're in a position of objectivity at all times in all of this, and certainly truth-telling, because this is the world in which you live. I'm not going to ask you to make a political message, but I'd like to ask you if you could advise Ohio voters as to what they ought to be thinking most about as they look at this issue. Where would you, from a legal perspective, where would you want to advise them?
Yeah. So I think that if I am an Ohio voter, and if I was an Ohio voter, hypothetically, what I would ask is, what do I think is the right approach of Ohio towards an important issue like abortion? And the median voter in Ohio, who I described earlier, is somebody who thinks that abortion should be legal for some period early in the woman's pregnancy. I think most Ohio voters also think that abortion should be allowed in situations like rape or incest. I'm not saying I agree with those positions, but that's kind of the median Ohio voter. I think what I would want them to know is that this amendment doesn't do that. This amendment does what the vast, vast majority of Ohio voters would not approve. And so, including things like partial birth abortion and parental consent. And so what I would say is, if your goal is to fit the median of Ohio voters, which is where most Ohioans are at, then this amendment is not where you, that voter, are at. And then instead, the fight should be in the state legislature, where you try to persuade legislators to come to a compromise where not everybody's happy, right? That's the nature of politics, but it's one where most people, most of the time, are able to get the policy that they think fits the good life that humans should be living.
Senator Obhoff, I have to yield the floor to you, sir. Do you have any questions for the professor?
No, I think that he's done a good job of describing everything in there. I couldn't agree more with some of the things that he said, particularly that this was carefully crafted to appear reasonable, to appear that it was restoring essentially the status quo of May 2022. That is definitely what I saw from the petitioners when they were out gathering signatures, both, frankly, when I talked to some of the petitioners, but also, yard signs that they would put up in town squares, literally saying restore Roe. And it's very clear that that's not what this amendment does, and that the language in the amendment is designed to make the voters think that you're doing one thing while actually you're doing something else, that the language is far more expansive than I think the proponents are willing to publicly acknowledge now. I'm sure that when we get into January or February of next year, if this passes, you'll see them come in and say, no, it did all these things that you accused us of doing, and now all of the laws that you passed in the last 15 years should be struck down. But they're not willing to say that now. And I think there's a real question moving forward. And Professor, I'd be curious what your thoughts are on this. A serious question moving forward on not just what does the language actually say, but because this is a constitutional provision as opposed to a statute. When we're addressing constitutional provisions, we try to figure out what the people thought it was they were voting for. That's why we look, for example, to the Federalist Papers when we're analyzing different provisions of the U.S. Constitution. And I think there's a good a strong question out there that judges will have to grapple with, that litigants will have to grapple with moving forward as to whether it is the strict language that is in here that needs to be adhered to, or whether it's what people who were proponents said you were voting for, what the voters thought they were voting for.
Dr. Strang, can I ask you to hold answering Larry's question? It's an important question. We're going to take a break and come back and give you adequate time to answer that question. And our panelists here as well, Jeff Sanders, Alan C. Duncan, Rob Walgate, Melanie Elsey, they'll all weigh in on this conversation as well. Coming up on The Public Square, an important program. Stay with us.
We will be right back for more on The Public Square.
Hi, I'm Abby Johnson. When I see the language in Ohio issue number 1, I recognize that Planned Parenthood is writing their business plan into your Constitution. I know because I worked there for 8 years. Ohio, please vote no on issue 1.
Back with you on the Public Square now. One of our guest panelists today is former Ohio State Senator Larry Obhoff. Larry, you were enunciating a question a moment ago for Dr. Strang, and would you just summarize that, and then we'll hear his response?
So when we take a look at the language, I think that it was carefully drafted to suggest to the voters that it is much more modest than it actually is. And so the proponents have said things like they're trying to restore Roe and denied some of the things that have been said about the issue. But the language doesn't really match up with their rhetoric. And my question for the professor is whether you think moving forward, if this were to become law, that's something that should be considered by courts when they're interpreting the language, not just looking at the language, but asking themselves, what did the voters of Ohio think it was that they were voting on? What did the proponents say that they were voting on, as opposed to what the proponents might come back with months from now when they say, hey, no, actually all those things were true. We want you to strike down every statute passed in Ohio in the last 20 years.
Yeah, that's a great question. And I really think it's a tough one when it comes to popular initiatives like the one here at Ohio. And I would say two main things, right? So one main thing is that if in Ohio's judges' own understanding of their power from the Ohio Constitution, they're authorized to interpret the law. And the law is, under that conception, is going to be the text that's put into the Ohio Constitution when read into the context of the time and place where it was at. And so that suggests, at least for much of the text, I'm going to have one caveat in a second, that what the judges should probably do is look at the text, and even if it's relatively broad and broader than maybe Ohio voters who voted in favor of it thought of it, that they should follow that text. The caveat that I would make, and it's a much more complicated issue, there's many other caveats I could make, but the one that I think is most relevant here is in those areas where it's not entirely clear whether the text best understood leads to a particular restriction or not. And here's what I mean by that. So I had said earlier that the right to make and carry out reproductive decisions is broader than the previous right to abortion. And that can lead to all kinds of, I think, really complicated and potentially expansive situations where abortion is allowed or the state is restricted. And it could be in cases like that where the text is vague or ambiguous, partly because of its dramatic breadth, that a judge might say reasonably in that area where the text is vague or ambiguous, at that point, then I'll look to what the Ohio voters understood they were adopting at that point. So that's kind of it's a very complicated issue. I think it's a great question. It's one that's going to happen if this passes, as you were saying, Mr. Obhoff. And I think there's probably other nuances as well.
Thank you so much, Professor. We're going to break in the middle of a segment, Alan, out of respect for the time that you committed to us, Professor. I thank you so much. You exceeded my expectations, which were high already. I hope you'll come back and talk with us again.
They're really low.
I really do appreciate it.
Yeah, thank you all. It's so great to meet you.
Thank you.
Thank you. Well, our panel has been listening carefully to all this. Dave, should we turn to them and start to get reaction and questions?
Yeah, I want to start with Senator Obhoff. And Larry is the former president of the Ohio Senate. He is now semi-retired in regards. We won't let him say he's retired from the legislature because we want him to go back.
Amen.
And he's a genuine public servant who's been a tremendous help to us. Larry, as president of the Ohio Senate, you all worked on a lot of issues regarding on the question of human life. And we've been looking at this proposed amendment and looking at the fact that we think that well, Melanie, how many laws do you think this has a potential of creating a train wreck with?
I've charted over 60.
Over 60.
Now, that doesn't just cover the abortion issue. It covers all 5 of the listed areas. And what I thought was most interesting in this language is what's missing is a grandfather clause. Because when we passed a constitutional amendment in 2011, or it went into effect in 2011 for the healthcare freedom language, they included a grandfather clause. Anything prior to March 19th of 2010 would not be affected. They did not do that in this language.
Well, Senator, that means they're going to upend a lot of stuff that you did while you were there.
I think that's the intent. I absolutely think that that's their goal, and that the reason they didn't put in a grandfather clause was because this language is designed in large part to convince voters that what they're doing is going back to the pre-2022 status quo, but actually give them the opportunity to then run into court next spring and say, no, all of these laws are in violation of the new provision. And when you look at what some of those are, as Melanie said, there are a significant number of them that are outside of the abortion area, but with respect to the abortion area specifically, those include a prohibition on essentially later term abortions where the child is capable of feeling pain, a specific provision prohibiting a method of abortion in the second trimester and later that involves dismembering. The Heartbeat Notification Act. So a lot of people talk about the heartbeat bill itself and the prohibition that's in front of the courts now, but there was language that was passed, I believe, in 2013 requiring a notification to the mother that if she was pregnant, that in fact the child had a heartbeat, and then a waiting period, a brief waiting period, so that they could make an informed decision. You had basic health and safety standards, and these are really, I think they're probably the largest target of the abortion industry right now. We put in place rules that said essentially you have to follow the same rules that hospitals have to follow. So medicines can't be expired, equipment can't be rusty, there have to be a certain number of beds available, et cetera, those types of things, and also transfer agreements with hospitals so that if you have emergency situations, we know that the patient can be taken to an ER if need be. And the left-leaning political activists in the state have decried those provisions for years. And frankly, that tells you where they're really coming from, that this is about protecting their sacred cow for politics, not necessarily protecting the health of the women involved. Because if that was what it was about, you would want the same health and safety standards applying at these facilities as apply at hospitals. You would want transfer agreement requirements and those types of things.
Dave, I know you have more you want to ask, and our panel wants to weigh in, and we're certainly grateful to have a lawyer here, Larry, to be with us, and there's much more to come on the Public Square. Once again, if you joined this conversation late, this is a critically important conversation. You want to hear the entire thing, go online to thepublicsquare.com or use our smartphone app for that.
What is the number one killer of us? It's not the police. It's abortion.
The abortion movement and Planned Parenthood were started by a racist. Margaret Sanger even rallied with the Ku Klux Klan. Abortion has decimated Black birth rates. Black babies in Ohio are 5 times more likely to be aborted than white babies.
Black folk, we are targeted for extinction. I believe that we have the right to exist.
The greedy, racist abortion industry's ballot amendment means no limits on abortion, even brutal, late-term abortions when the baby can feel pain.
We're talking about the future of our country, our race, our society.
Stop Issue 1. Vote no.
You can't pray one way and vote another.
Back into the topic today on the Public Square now. Here's Dave Zanotti. Dave.
Senator Obhoff, my question is this. When we look at the amendment, it creates a new right that the professor agrees we've never seen before. It's the right of reproductive decisions, including but not limited to decisions on contraception, fertility treatment, continuing one's own pregnancy, miscarriage, care, and abortion. These are all matters of public policy, to be sure. But the challenge that I have is there are also methodologies by which Planned Parenthood and other abortion providers, nationally and in the state of Ohio, receive funding from both state and federal dollars. Now, back in 2016, and I'm guessing that you'll remember this, the legislature decided in Ohio that they did not want to send those grant monies through to people that either performed or promoted abortion, and they passed legislation accordingly. And there was a defunding of abortion clinics, particularly Planned Parenthood, in the state of Ohio, and in regards to some of this grant money that comes to these other areas. Planned Parenthood sued, and they lost that suit on appeal. I think I heard Professor Strang basically say that if, in fact, Issue 1 became law, those funding bans would be unconstitutional. Is that how you read it?
Sure. Well, I think that that's their intent. I'm not sure that that's how courts will interpret it, but that's certainly part of what they're trying to do here. They're trying to undo the legislative decision to reprioritize funding to different organizations and essentially be able to run into court and say, listen, we're entitled to X number of dollars in the budget. We're entitled to receive any money that other organizations might receive, and try to get the court essentially to take the place of the legislature in setting the state budget. I think they're essentially putting their business model into the Ohio Constitution, or trying to put their business model into the Ohio Constitution.
Well, for the record, those who have been listening to the Public Square and criticizing me for my enthusiasm in regarding to making that point very enthusiastically, I think I now have confirmed by two people with a lot more legal background and legislative experience than myself. That's what we see, the same thing. Larry, we see this as basically writing your business plan into the Constitution, but what's bizarre about that is that you're creating human rights out of it, which elevates the entire conversation in regards to how judges are going to have to look at this.
Yeah. It's. I think it'll be a difficult question that the courts will at some point have to grapple with. And obviously, as a former legislator, I think the legislature should be setting the budget. But it's pretty clear to me that this is at least what they're attempting to do.
I think in addition to in tandem to the funding question is the question of access. Because school districts are political subdivisions of the state, and so school districts will not be able to, in the same language as restricted for the state, be able to burden, penalize, prohibit, interfere with. So Planned Parenthood over the life, well, at least since the last 30 years, they have not had access to all schools. They would like to have access to all schools through state policies. They were not successful in doing that, and we have a whole separate story on how that happened. But so they've had to go to all 615 plus districts, district by district by district. So now their position is going to be approach a district, and they will be able to say, you can't interfere. We are assisting these individuals in making decisions. For contraception, for example, in terms of the school's sex ed programs, you can't shut us out because that would be interfering, that would be discrimination. So local school boards, locally elected school boards' hands are going to be tied as to their ability to say no to programs that they would disagree with.
Well, let's let the former Senate president be the judge of that. Larry, could you see that kind of a conflict arising?
Well, again, this is why the language is intentionally vague, and you see language in there that says not just directly but indirectly impacting any of these things. I bet if you asked 10 different people what does indirectly affect this mean, you'd get 5 to 10 different responses. And if this was statutory language, there's a good chance a court would say that it was so vague that it was void, which is a principle in law, that if something is so vague it can't really be understood, or it's essentially a meaningless restriction, it's no longer valid. But here, because the language would be put in the Constitution, I don't think you'd be able to do that. And I think that language was chosen very deliberately so that it can mean whatever its proponents want it to mean 2 months from now, 10 months from now, 10 years from now. It could be an ever-shifting goalpost, essentially.
Larry, what advice would you give Ohioans? And I'm not asking you to be political or even to tell them how to vote. What advice would you give them on how they should look at this as an amendment to their Constitution?
Sure. Well, I would say two things, and one thing that I have been saying around the state when I've had the opportunity to talk about this, which is actually look at the language, go to seethelanguage.com, the website that you have set up for this, so that you can see not just the language itself, but also essentially sentence diagramming the way we would do in an English class in 5th or 6th grade to show what the words actually mean, why they were chosen, how they're used, and how they interact with each other. And my take on this for the people of Ohio is very similar to Professor Strang's, which is this is not what people think. This is certainly not what the proponents have said it is. They have presented a very specific picture designed to make people think that they're going back to the status quo at the beginning of last year. And instead, this would be among the most expansive laws anywhere in the country, certainly. And as you heard Professor Strang note already, our nation overall has some of the loosest laws anywhere in the world. But I would also say the ads have been, frankly, in my opinion, very misleading when they focus on things like miscarriage care and birth control. Yes, that's in here, but that's in here just so they can run those ads. There isn't anybody who, I'm sure there are some legislative proposals dealing with those things, but I don't think there's anybody who seriously believes that Ohio is ever going to ban birth control. There is nothing in Ohio law right now that would criminalize miscarriage care, and there never would be. So these are straw men that were set up for the purpose of being part of the messaging later on. And if you actually if you separate yourself from the commercials and you actually look at the language, what it says is it will be very, very challenging for the legislature to ever regulate abortion, and if and when it does, to the extent that they have some ability to do so in here, it can essentially be overruled. So you look at the language of the amendment itself. It says an abortion may be prohibited after fetal viability, but then in the very next sentence it says, but in no case may such an abortion be prohibited if in the professional judgment of the patient's treating physician it is necessary. And the exception subsumes the rule there. So yes, you can regulate it, but any individual doctor at any individual time can say, well, I disagree in this instance. So the ability to regulate it is essentially meaningless under that language if it's applied the way that it's written.
And Larry, the guardrails that have been put in place in statute with regard to the abortionist determining viability is that there has been a requirement that a separate doctor sign off as well. It's not just in the hands of one attending physician. There has to be a second person signing off on the question of viability, which this language strips that out.
And we're going to take a break right here and pause this conversation. We're aware that some stations find it necessary to cut away at this time. If your station is one, please join us online for the rest at thepublicsquare.com.
Spreading the light of liberty across the land. Now back to the public square.
An in-depth conversation today on the public square. So glad that we could have the law professor with us, Dr. Strang, and of course the former state senator from Ohio, Larry Obhoff, who had to leave the studio now, Dave. But boy, what tremendous assets they were to the conversation.
Well, we wanted to bring more intellectual capital and experiential capital into this conversation because as we have been talking about See the Language around the country, we have taken some pushback, though very little. And interestingly enough, I think people should know that the pro-abortion community and the backers of Issue 1 have failed to respond to our challenges. They have failed to disclose who wrote this amendment after repeated requests on our part to their attorney as to who actually wrote it. We have yet to find one substantive point of refutation in regards to the questions that are being raised at seethelanguage.com. It seems like what they're doing is running away from what they're asking the people of Ohio to embrace. And that is a very discomforting thing because the campaign is being run on pure emotion in regards to the Vote Yes team. And it's very frustrating because when you talk with people who do law for a living and have consequentially seen themselves bearing the load of what do laws mean and how do they work, they've been on the firing line. They understand these things. They're telling us across the board, this is really a bad idea. But there's so much money in this process that's coming in from the abortion industry around the world to support issue 1 that it's very difficult to prevail in that message. So we're definitely counting on people's prayers and the hopes of the good minds and the good faith of the people of Ohio. Rob, what are you seeing?
You know, it was nice to sit with the professor and the former Senate president and hear them talk about much of the same things we've been talking about. So it proves to me maybe I'm not as crazy as I thought I was in regards to law and the application of it. But as
we knew that all along, Rob. So
as Larry talked about the commercials, and we've talked about the commercials around the table during staff meetings, but I kind of went back to 2009 and the fight against the gambling industry and the casino industry and all the promises that were made during those commercials, all the things that were supposed to happen, all the tax money that was supposed to come in. And once they get in the Constitution, they don't have to deliver on any of the campaign promises. You know, after it happens, it doesn't matter. So that was interesting to me about the similarities maybe between the two when it comes to the constitutional language.
You don't have to run for re-election for a constitutional amendment. It's in there.
Yeah, it's like handing someone the largest legal hammer that you have in the state and say, swing away.
Yeah. And we need to look at it as a positive, right? In the fact that we have access as Ohioans. I tell people all the time, if you live in a state where you have the ability to amend the Constitution, you ought to view that as an amazing responsibility. There are states around the country that would love to have access. So the states that do have that need to understand that there's a responsibility that comes with it, something you must take seriously.
And just so people will know, we have challenged legally constitutional amendments, provisions, adaptations. We've been in court a lot over 43 years. Rob, you and I experienced a 3-year contest where the legislature was attempting to tweak constitutional language and was being prohibited. And one of the things that we found is once you hand over that hammer, then it becomes a question of what the courts are going to be permitting in regards to the debate. No one's even asked the question, who would get standing in a courtroom to challenge anything the abortion industry does, claiming this is their authority and their power? How would someone even get standing in a court to challenge them based on this vague language?
Well, the silence and the chuckling is thinking back to that experience when I sat in an appellate court. We sat in appellate court, and I heard the state's attorney in that case say they don't have standing because they haven't been harmed any more than any other Ohio taxpayer. And I remember looking at the lawyer and saying, did he just say that out loud? We won. He's saying we have harm. Like, we're taxpayers. We have an interest here. This is amazing they admitted that out loud. And then to realize that that's how the court ruled. And I'm like looking around like, wait a minute here. That's not how this is supposed to work. So the question of standing when it comes to constitutional law is a very intense question where precedent has been set, where I feel precedent was wrong.
Basically, what that means is the judicial system will become the legislature because the citizens won't be able to affect the decisions of a court based on standing, as we can now affect the outcome of legislation because of the elected officials who serve. We won't have the access to the courts to just challenge what the abortion industry will do. So the courts will fly solo on this because they have completely written out the legislative branch and all of its subdivisions altogether.
And you never know what kind of a judge you've got ruling on this, right?
Yeah.
Could be somebody who's very sympathetic, or someone just wants to make it up.
Yeah, you're right, Jeff. Wayne, we closed the arguments where we began. From the very beginning, we said this is not the way Americans do law. Mm-hmm. This is not right. And now, after going over this for months and months and months, we've come to the same conclusion. And listening to people pro and con, this is not a smart way to go about this. Not in Ohio, not in Florida, which is coming up very, very quickly, Arizona as well, New York, and many other states. This is a serious question of what we would call jurisprudence. How are we going to govern ourselves? Is this the way you want to do, to hand the biggest hammer of law in your state to the abortion industry? It doesn't matter in a one-sided debate. Doesn't make sense. So what do people do? Well, first off, around the country, please pray.
Yeah.
The hours now that are left are very few before this election happens. It's right here. So please, please pray. And I would encourage anyone who knows anyone in Ohio to talk to them and visit and encourage them to visit seethelanguage.com. We created a simple tool whereby people could look at this language and ask themselves, is this the way we want to be governed? And I think after hearing all the people who have been to that site and reviewed it and looked at it, it's very clear that it's hard to find anyone who really, when they think this through, says this is the smartest way to go forward. But if people don't see the language, then they're not going to know. So that's one way you can help dramatically. Melanie, Rob, Jeff, Alan, what other suggestions would you have for folks?
As a former pastor, I would like to urge all the pastors who are listening, or everybody else, just tell your pastor, please, say something from the pulpit, comment on this, encourage people to go to seethelanguage.com. And if I were pastoring a church, I would strongly urge everyone to please vote no. You are not in violation of any IRS regulation. You are not in any danger to say that. You are completely within your rights to say that from the pulpit.
Even more so, as people are contacting friends and family to go to see the language, you can exponentially create an effect off of that if you encourage them to also post it for their friends and neighbors. If you're communicating with somebody in Ohio, that person has friends and family and neighbors in Ohio.
Right.
Encourage them to do the same, to post on their texting, through their phone, or social media, the website, See the Language. It's so effective. And it's also available in Spanish.
Yeah. Since you all created this and I had no hand in it whatsoever, I can say I've never seen a more helpful tool in any election than seethelanguage.com. It's just a masterful job you guys have done there to draw out the real meaning behind each and every word and phrase in this proposed amendment.
Well, thank you, Wayne, because that is what we do, and it's a privilege to do so. We couldn't do it without the tremendous support of our listeners. In some cases, the patience of listeners who are living in a state where this is not a debate that's right now coming at you.
Yeah. Thankful for all who listen to the Public Square. Thank you for joining us.
The Public Square is a broadcast service of the American Policy Roundtable.